Scott, what is the maximum interest rate that somebody can charge their buyer?
Well, everybody wants to charge as much as possible, right?
Absolutely.
So the first thing I always like to at least tell people is be reasonable. In the current marketplace, rates might be 3.5% to 5%, right? Oftentimes we're collecting 8, 9, maybe 10% sometimes. Do we need to collect more than that, is what you always want to ask. Now, the rule of thumb is this. There is what is called the APOR, which is the average prime offer rate. That is an index that is published every Tuesday by the government.
Okay.
That fluctuates usually with the prime rate a little bit.
Mm-hmm.
From there, if you have a first lien mortgage, meaning there is no existing debt, your APR, and that's your annual percentage rate, not your interest rate, cannot exceed 6% over the APOR, or excuse me, 6.5%.
Is that the law or
That is
just
Dodd-Frank.
Dodd-Frank? Okay.
Next, if you have an existing mortgage, so maybe you bought the home subject to the existing debt, maybe you went to a bank and borrowed money, maybe you have a first lien with private capital. That is called a subordinate loan. Now we can be 8.5% over the APOR in that instance.
What if you've already set the rate and the APOR goes through the roof or something?
Well,
then
if you exceed, so Dodd-Frank has 3 levels.
Mm-hmm.
There is the QM, qualified mortgage level, which we don't want to be in. That's where our bigger banks are and mortgage companies, etc. We like to be in what's called the high cost loan, which is what I just described.
Okay.
That 6.5% versus 8.5%, whether you have no debt or existing debt on the property. If you exceed that, you become a high priced mortgage.
Mm-hmm.
Now, if you're going to sell a home to somebody, you're going to fall into that category, your borrower must go online and take a HUD course. They must get a certificate and provide that certificate to you. And in the loan processing, there's probably going to be a few extra disclosures that have to be signed off on. Now, I don't like that because think about this. If you go online and you take this HUD course, what is it going to tell you? Hi, I'm stupid for paying so much in interest rate? I don't know, but that's my thought process. I always get a little bit. So
Have you ever had anybody have to do that?
I have heard of few people doing that before. And sometimes in some situations, maybe you can do that. I just don't think there's a need to push things that high.
It's kind of like a big L on your forehead.
Pretty much.
Okay. Do I have to wait 7 days for the underlying lien disclosure?
So what the question is here in Texas at least, we have what is called the Texas Underlying Lien Disclosure
Right.
Notice. I don't know if other states have that or not, but at least here in Texas we do.
Okay.
And all what that document says is that we must provide any buyer, whether it's us buying from a seller, an investor, or if I'm selling to a home buyer, the name, address, and phone number of the lender, their account number, loan balance, interest rate, and what the monthly payment is, the principal and interest payment, and whether or not they're providing me consent to do this. So here in Texas, though, it's required to give that to any buyer at least 7 days prior to closing. Now, if not, keep in mind that buyer can terminate the transaction for any reason within that 7-day time frame of receipt. That's not like an option agreement, okay, Susan? Where maybe it's because of inspections you want to terminate. This is any reason.
Wow.
Often say the sky is blue.
Under
I want
the
to
7
terminate.
days.
Yes. Now, knowing that, if we're in a pre-foreclosure mode, that gets waived if we don't have the time frame for it.
Okay.
That's number one.
Yeah, that's good.
Number two, is it smart to wait it out? Yes. Because you want your buyer to have an opportunity to read through your paperwork and your documents and to understand this.
Okay.
However, can you close earlier? Sometimes you have a buyer, maybe they're living in a hotel because their rent expired, their lease, and they had to move into a hotel short term.
Okay.
Or maybe they got transferred to their own business, they not really want to live, they're in a hotel, and they want to get out fast. Can you do that? Yes. You can still close them. What we're going to do, though, is we're going to hold off on the funding until that 7 days has expired. What I don't want to do is have to unwind the transaction and go out and try to collect money back from a seller or an investor, whom else it might be out there, that's almost impossible to do.
Okay, let me ask, because I know there's so many specifics, like you have to mail it to them, put it on the door, all of that. Is this emailed and then they have 7 days? And what if they don't see it for 3 days? Is that too bad? You emailed it on the first of the 7 days? Don't be laughing at me. These are things people.
Okay. You're talking about evictions.
Well, I know.
Versus this notice. Okay?
No, I know, different days, but if
It is
there's 7
signed.
days,
It is signed.
signed what? Is it?
It is signed and dated.
And it's emailed, and then they have 7 days?
No, they have to sign it
Okay,
and date it.
okay.
That's the test. It is not emailed, it's signed and dated.
Signed it, so 7 days out, they have to come, you have to sign this, and then in 7 days you can close.
You can close before if you want to.
If you want, if they're okay with it.
Yeah. And by the way, you're getting off track a little bit, okay? Because you're still having to process the buyer, and that takes anywhere to 10 days sometimes. So, with the underlying lien disclosure notice, we like to wait the 7 days if possible.
Okay.
It's a smart thing to do.
Okay, so next question goes back to processing the buyer through an RMLO. Do you have to do that? I know you require it or suggest it.
I suggest it. I can't require anything. I'm not the mortgage police, okay? Every seller who is the lender has to make the decision. I'm not the decision maker as a closing attorney. I process all my buyers regardless.
Right.
But the guiding factor there is the SAFE Act in that instance. So if you're under the SAFE Act, here in Texas, we have this 5 property de minimis rule. If you're in other states, you may have to do it on every transaction. I like to do it on every deal because it makes it idiot-proof. It just helps me know that my buyer has the ability to qualify for the loan, and I won't ever want to be sued saying I sold somebody a home they couldn't afford.
Right. But also I've heard that it's best to do that if you ever want to consider selling the note down the road, because a lot of note buyers won't buy an owner finance note without an RMLO in the mix.
Well, most note buyers ever want to see a loan processing package.
Okay.
And when they know that the loan was originated properly and the RMLO packaging helps to verify and validate that, yes, it will help you sell your note quicker and for more money.
Okay. Okay, so if I decide I don't want to use a loan servicing company, I've just got a couple owner finance deals and I'm going to do it myself, can I charge a service fee?
Well, first off, if you have an existing mortgage on the property, now the seller and buyer, they can agree not to use a servicer. It is not a mandatory requirement. The servicer is there as what I call the fraud preventer, because so often sellers may get in trouble from other things. They keep the buyer's monthly payment, they don't pay the mortgage company, and they go off to the Bahamas or wherever it might be, or they pay their mortgage or they pay their car payment or something instead, to the detriment of the buyer. So I don't like that. So one of the things I do in our law office when we're closing a transaction is, if you can't demonstrate you have the ability to do things right, you don't have the sophistication and or the financial ability, I will not allow you to close a transaction without a loan servicer. That is just my internal policy. So maybe I do police things a little bit that way, because I've seen too many bad things happen. But end of the day, the answer to the question is no. There is no legal requirement at this time.
But I think
servicer.
The seller feels more safe and secure too.
Well, the buyer does.
The buyer does.
Yes.
Well, you would think that the seller would too, wouldn't they?
The seller doesn't care.
Oh. Okay. I would think I would care if I was the seller.
Well, you might, but it's really there to protect the buyer from the seller.
Okay. Okay, next question. You ready? I'm trying to refinance the existing lien, but can I close the wrap ASAP first?
Can I close the wrap ASAP first? What in the world does that mean?
I don't know, that was on Facebook. I'm trying to refinance the existing lien.
I get the question.
Okay.
So there's an existing mortgage and they want to sell the property before they refinance it.
Right.
So the question is going to become is, who holds the first lien mortgage? If it is an institutional mortgage and you have sold the property to a third party, no, you're not refinancing it.
Okay.
If it is a small commercial bank or it is a private lender and you're going to refinance it through another private lender or commercial bank where you can assign the original first lien mortgage along with its title policy to the new lender, oftentimes you can, but you're not going to be able to go to a mortgage company and refinance it. So if you want to refinance the property, let's put the buyer in the property under a temporary lease, get the refinance done, and then close the deal. You know, we can still give our buyer credit for those rental payments towards their mortgage payment so they don't get taken advantage of. There are ways to make that happen. So just be smart in how you do that.
Okay. Here's another interesting question on this whole double close thing, okay? What do I need on the sales contract special provisions when I'm doing a double close since they do not own the property yet?
So again, people don't know how to ask the question right.
Of course.
So a double close for everybody is where seller A is selling to investor B and investor B is selling to maybe another investor C or a homeowner. Pretty simple. So there's many ways of doing that transaction. What you cannot do is you cannot use party C's money to close the AB transaction unless you have got written permission from all parties involved. Party C has to agree that you can do it, and party A has to agree you can do it. Now, if you are doing a flip transaction, let's say you're doing an assignment of contract. If you are assigning a contract at a reasonable price, no one cares about that. If you are collecting a very large assignment fee between the A, B, and BC transaction,
Right.
do you really want
you don't
party
want them
C
to know.
to know how much money you're making?
Right.
Because if you intend to sell them the house again, and they find out you're making this exorbitant assignment fee, next time you try to sell them the house, what's going to happen? They're going to negotiate the heck out of you, or they'll never do business with you again. One or the other, right?
Right. Yeah.
So you want to not disclose that. So in that situation, you may want to close the AB deal first, which means if you don't have the cash, you have to borrow transactional funding, which is short-term, one-day money.
Okay.
It's just there's a small cost along with that, and it's just a
How
cost of doing
small?
usually $500 to 1% based upon the transaction.
Okay. And
And
do you
then-
qualify to get that money?
No,
No.
typically not, because the BC deal is already funded, just hasn't closed. So knowing that they've funded the deal, you close AB in the morning, you close the BC deal in the afternoon.
Okay.
But there's going to be a small fee associated with that, and you usually have to pay for another title policy, unfortunately. And you must close them in the same title company within the same time frames, pretty much. Okay?
Okay.
Title companies want to control that. So the other thing you can do is called a pass-through. And the pass-through is where all parties agree. So you actually use party C's money to close both sides of the transaction, and everybody agrees to it. And in that instance, you can pass the title policy through, only pay for one title policy.
And how often does that happen?
Often.
Really?
In the investment
If it's
side of
a
things.
reasonable assignment fee.
Yeah.
You wouldn't do that on a outrageous assignment?
No, I would not.
Okay. I learned something
Good.
new. Okay, ready? How do I convince the seller? This is from a new investor, by the way, just getting into owner financing. So he's asking, how do I convince the seller that I will make their mortgage payments when it's my first owner finance deal and I have no history?
You better learn how to talk a good game. You know, it's hard.
Act as if.
Yeah. You know, if it was easy, everybody would do it. But it's all about your credibility. It's about your honesty. It's about knowing how to explain things right out of the chute. If you walk in and you don't know the answer to things that they're asking you questions with, or you cannot, talk your way through it sufficiently to give them answers, they're probably going to feel uncomfortable with you. But if you have enough education, you've practiced enough to do this, you can properly explain things and give them the sincere answers that they need. You're probably going to be successful to do that.
Be hard for a newbie.
It's hard.
Yeah, I
It's
mean,
tough.
it's easy for you, you've done 7,000 of them. You're pretty credible, but newbies,
No, it's hard.
it's hard. So you just have to be confident.
You do.
Right? Okay, what happens if my buyer files bankruptcy?
So this is a home buyer. Okay. They file bankruptcy. What you have to do is make sure you file your, oh Lord, what's the word I'm looking for? The proof of claim with the bankruptcy court. So you secure because you're a secured creditor in that bankruptcy. Now, what happens in a bankruptcy scenario is they're usually behind in payments, hopefully no more than a couple of months.
Right.
You've posted them for foreclosure, and of course, the day before foreclosure, they file bankruptcy.
Yep.
Then there's going to be about a 60-day time frame in which they are getting together information and filing their plan. And so in that time frame, of course, we're filing our proof of claim.
Yeah, but in that time frame, you're out of, you gotta make that
You are.
mortgage payment for 60, 90 days.
You are. Now, after that time frame, that buyer has to start making payments, and usually they're going to pay you direct. Now, if they're not paying you direct, if they're not paying the trustee, under some new bankruptcy laws, the trustee is going to dismiss them from the bankruptcy. You can then proceed for foreclosure again.
Okay.
If that doesn't happen, and they're not paying you, then you can hire a bankruptcy lawyer, ask them to go in, file a motion to lift stay, which means getting permission to foreclose, and then go foreclose on them. The most important thing with this is understand the process and be proactive.
Right, and so many people know how to play that game.
They do.
Like they wait till the last minute. What about, and I hear this all the time, and we've had situations like this when they file a pauper's affidavit.
Well, that's not a bankruptcy though. That's
Okay.
in an eviction process.
That's an eviction.
Yeah. So a pauper's affidavit is if you are evicting somebody, you win the eviction and they want to appeal it to the county court.
Okay.
Or I'm not sure what other states might have, but here in Texas, the justice court has exclusive jurisdiction over evictions, and then you appeal it to the county court.
Okay.
Well, usually there's a bond set on that appeal. And so oftentimes they can't pay the bond, so they file what's called a pauper's affidavit, which is an inability to pay status. Now, when they do that though, they have to pay at least rent into the court registry every month. So when they file that appeal with the paupers,
The entire rent?
they're paying the rent on the property into the court registry in order to validate the appeal.
Okay.
And then every month that rent comes due thereafter, they've got to pay that rent into the
So
court
they
registry.
pay it into the court, but does the court pay it back to you?
Only if you win. If you win, you get it.
And how long could that process be?
Well, at least here in Texas, that appeal process is probably between 3 and 4 weeks. So it's not that long.
Okay.
But there are risks in this in our business, unfortunately.
Right.
Bankruptcy can happen. If you process your buyer right, you check things out, you use that armalo, oftentimes you can head that off. Now, bad things do happen to good people, and there are bad people who are going to take advantage of you.
Right.
Trying to avoid those bad people by processing the buyer, actually looking at their credit history, those kind of things, it is a great way to avoid that. It's not a guarantee. Same thing with an eviction process. You know, if you own a home with seller financing, someone files bankruptcy, they get thrown out for some reason, or you're able to remove them, you then proceed to foreclose, they're still there. You have to file an eviction. So at that point in time, you go to the eviction court, you get permission to evict them, you get a judgment, they do that pauper's affidavit on appeal, right? There are some delays you got to deal with, and that's just life in our business. There's risk to everything we do, and you have to be willing to absorb that risk in this industry.
Okay. We're going to take a break. We only have
You asked some of the good